Also remember that Parkinson's law applies in the profession of law more than in any other. The less work there is, the less inclination there is to put your mind to it. So the less will be your experience. The less will clients seek you out as advocate, and so you will have less work, all in a downward spiral. And the more you are engaged in work, the better will be your application of mind, the sharper will be your intellect, and then everything will be in an upward spiral, only the sky being the limit. But work here means being occupied, not necessarily paid work. The worst enemy of hard work is a fixed monetary reward. There is no incentive when your senior keeps paying you a stipend. Of course, if it is necessary for you to survive, take the stipend, but don't depend on it forever, because you are then in the position of an employee or an office clerk. You will soon begin to work less and less, and only in office hours, and then in company of other lawyers, you will begin to complain how poorly you are paid. There are no office hours for a practicing advocate. You have to be mentally engaged day and night. Remember that when you assist another person to argue, you must be of real use to it. This you can do only if you have looked up or studied the facts, made short notes, looked up the entire law pertaining to the case. Not only relevant law, but also law having some remote connection with the facts. This is because, although in a court of law, only relevant facts are to be stated, there is one very important but least known section of the Indian Evidence Act, which is section 165, which reads as follows. The judge, in order to discover or to obtain proper proof of relevant facts, may ask any question he pleases, in any form, at any time, about any fact, relevant or irrelevant, and neither the parties nor their advocates shall be entitled to make any objection to such question. It's a very important section. This is because a judge at a trial or in a proceeding is expected to explore all avenues open to him or her in order to discover the truth. So in an Indian court of law, as an advocate, you must be prepared not only the facts of your case, but all possible permutations and combinations that can be imagined. So when you have a brief, you must always go beyond it and be ready with answers to the judge's questions, relevant or irrelevant. And you can be sure that a judge will ask many irrelevant questions, and you have to patiently and politely answer them. Next, after you have read your brief and reread it, take time to reflect. Think on it. It helps greatly. This is the advice I was given by C.K. Jaftari, who was for many years Advocate General of Bombay, then